Sleep 2 Business Genius, Business History, Fact Number 5 of 107-minute read. The law that built business. Before commerce could truly flourish, it needed something invisible but essential, a shared set of rules. Ancient Rome created them. And in doing so, it laid the legal foundations that still underpin contracts, trade, and business across the entire modern world. By Sleep to Business Genius. Ancient Commerce. Rome, Italy, 450 BC, 530 AD. A Roman wax tablet contract beside the columns of the Forum, the legal and commercial heart of the ancient world's greatest trading empire. Close your eyes. Let your breathing slow. And walk with me into the Forum. It is the heart of ancient Rome, an open rectangular space paved in gleaming stone, flanked by marble temples and colonnaded halls, alive with the noise and color of the greatest city on earth. Merchants argue prices. Lawyers confer in low, urgent voices. Scribes scratch records onto wax tablets. Slaves carry goods between warehouses. Citizens, senators, tradesmen, and foreigners all mingle in the brilliant Mediterranean morning, doing what Romans do best: business. But what makes this commerce possible is not just the goods being traded, or the money changing hands. It is something invisible and yet absolutely essential. It is the law. A shared, enforceable, written framework of rules that tells every person in that forum what they can promise, what they must honor, and what happens if they do not. Before Roman law, a deal between strangers was only as good as their personal reputations. After it, a promise could be enforced by the state, and commerce between people who had never met, and might never meet again, became possible. The 12 Tables. Rome, 450 BC, the first written legal code of the Roman Republic. The story of Roman commercial law begins in 450 BC with a remarkable act of political courage, the 12 Tables. For centuries, Roman law had been unwritten, administered by patrician magistrates who applied it selectively and often arbitrarily. The plebeian class, ordinary Roman citizens, demanded that the law be written down, made public, and applied equally to all. The result was a set of 12 bronze tablets displayed in the Forum for every citizen to read. They covered inheritance, debt, property, and the conduct of legal proceedings. They were not sophisticated. They were blunt, specific, and practical. But they established a principle that would echo through 2,000 years of legal history: the law must be written, public, and the same for everyone. For commerce, this was transformative. A merchant could now enter a contract knowing exactly what his legal obligations were, what remedies he had if the other party defaulted, and what a Roman judge would be expected to do. The uncertainty that had crippled complex trade was replaced, slowly and imperfectly, by predictability. Scales. Legal heritage. The 12 Tables of 450 BC are considered the foundation of all Western legal tradition. Their core principle, that law must be codified, public, and equally applied, runs directly through the Napoleonic Code, 1804, the German Civil Code, 1900, the legal systems of every country in continental Europe, and the commercial law frameworks of more than 150 nations today. Contracts, partnership, and the art of the deal. As Rome expanded from a city-state into a Mediterranean empire, its legal thinkers, the jurists, developed an increasingly sophisticated body of commercial law to govern the transactions of an economy that now spanned 3 continents. The Roman law of contracts was built on a deceptively simple idea: that a binding agreement required consent, and that consent once given created an obligation enforceable by the courts. Roman jurists identified different types of contracts for different commercial situations. The emptio venditio governed the sale of goods. The locatio conductio covered hire agreements and employment. The societas created legal partnerships between business associates. That last one, the societas, deserves particular attention. It allowed 2 or more people to pool their capital and share the profits of a joint venture, with each partner bearing personal liability for the enterprise's debts. Sound familiar? The Roman societas is the direct ancestor of the modern business partnership, a legal structure still used by law firms, medical practices, and trading houses around the world. Roman jurists understood that different commercial relationships needed different legal structures. In giving commerce its vocabulary, contract, obligation, liability, remedy, they gave it the language it still speaks today. The law that survived an empire. The Western Roman Empire collapsed in 476 AD. Its legions disbanded, its roads fell into disrepair, its cities shrank. But Roman law did not collapse with it. The Emperor Justinian, ruling from Constantinople, commissioned a monumental task to gather, organize, and codify the entire body of Roman legal writing into a single authoritative collection. The result, completed in 534 AD, was the Corpus Juris Civilis, the body of civil law. It ran to hundreds of thousands of words, covering everything from property and inheritance to trade, slavery, and public administration. It was the most comprehensive legal document the ancient world had ever produced, and it would prove indestructible. When medieval European universities began to revive in the 11th and 12th centuries, Roman law, as preserved in Justinian's corpus, became the foundation of legal education across the continent. It shaped the commercial law of Renaissance Italy, the merchant codes of medieval France, and the great civil law codifications of the 18th and 19th centuries that still govern most of the world today. Still in use. Concepts coined by Roman jurists, contract, obligation, good faith, bona fides, property, liability, partnership, and legal remedy, appear unchanged in modern commercial law across Europe, Latin America, Africa, and Asia. When a company signs a contract today, it is using a legal framework whose essential architecture was built in Rome more than 2,000 years ago. What the Romans understood. The Romans were not the first people to write laws. The Babylonians had the Code of Hammurabi nearly 2,000 years before the 12 Tables. The Greeks had their own legal traditions. But what the Romans did, what made their legal system uniquely durable, was treat law as a living, rational discipline. They argued about it, refined it, wrote commentaries and counter-commentaries, and built a profession of jurists whose job was to think carefully and systematically about what justice actually required. And they understood something that every business person intuitively grasps, that commerce requires trust, and trust at scale requires rules. Not customs or traditions or personal relationships, but written, enforceable, publicly known rules that apply to everyone equally, regardless of who they are or where they come from. That insight, so practical, so Roman, is the foundation of every commercial legal system on earth. The forum is silent now. But the law it gave us still speaks. In every contract signed today, the hand of Rome is present. Tags, Roman law, ancient Rome, history of contracts, a business law, 12 tables, Justinian Code, commercial history, legal history, sleep learning, economic history. Sleep to Business Genius weaves 100 fascinating business history facts into soothing, story-driven narratives. This is fact number 5 of 100. Part of 100 Facts About Business to Fall Asleep To, available as a full narrated video on YouTube.